What with all these fantastic products that the federal government clearly doesn't want you having out on the market, you might be considering getting into NFA items. We're going to talk about buying NFA items in this series, starting with one of the first questions lots of people ask. Should I get one of them gun trusts? The decision will come down to a number of factors, so let's talk about them.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
I hear something like this all the time. Well, I'd like to get a suppressor, but I need to get one of those trusts first, right? Now, there are lots of good reasons for having a gun trust, but there's also a lot of misinformation out there that might be influencing people to go one way or the other. Before we dig deep into what went down, I'll just say up front a few good reasons for exploring a gun trust. If you've got a spouse or BFF who often takes your guns and needs to be able to use them when you aren't around. Perhaps you're at the end of your life, or you don't have a will, and you want to make sure your NFA items don't wind up being fed to a government crunch machine. Or perhaps you hate your children, lineal descendants, or whoever is in your will, and want to keep your neato guns and gear away from them. Now, those are just a few good reasons for exploring NFA trusts off the top of my head. So now, for those of you who can stomach more than 30 seconds of video, let's take a step back and talk about how this nonsense even came to be. As you know, and as is an affront to our basic human dignity, the NFA regulates the possession and transfer of certain firearms, with the word firearm including suppressors and machine gun conversions. When you jump through all the hoops and acquire an NFA firearm, only the person to whom the firearm is registered can lawfully possess it. Now don't get ahead of yourself, we're going to talk about what these words mean in a minute. Here's a hint. It isn't the ordinary human understanding of the words. Remember, this is government speak we're talking about. So let's start with what a person is. Now don't roll your eyes. Like I said, government speak. We have to translate it first. 27 CFR 47911 defines a person as a partnership, company, association, trust, corporation, estate, or individual. So now you're starting to see the breadcrumbs. This means that it's not just normal squishy blood bags like you and I that can possess NFA firearms, but also legally distinct associations of blood bags. The most popular of these forms to be used with NFA firearms over the years has become the trust, for a variety of reasons that we'll discuss. First, we'll talk about the state of the law where the NFA trust became really popular. For many years, the federal regulations required any individual who wanted to purchase or create an NFA firearm to fill out the appropriate form, obtain approval from their chief local law enforcement officer, which we'll call the CLEO, and submit fingerprints and passport photos along with the application. Now, despite owning NFA firearms being totally legal in the vast and sweeping majority of U.S. jurisdictions, this CLEO approval posed huge problems. Basically, some politically motivated or simply FUD-minded chief law enforcement officers would simply refuse to sign off on NFA applications. This basically created scattered bans on NFA firearm possession in localities all over the country. Remember the requirements for fingerprints, CLEO sign-off, etc.? Well, it used to be that those requirements only applied to human meat vessels and not legal entities like trusts. This means that people whose garbage CLEOs would refuse to sign off on Form 1 and 4 applications could get NFA firearms if they just cooked up a trust real quick. Plus, the advantage of avoiding prints and photos was attractive to other people. As NFA firearms, especially suppressors, grew in popularity, a cottage industry around gun trusts exploded. They became so common that many gun owners believed that they were a necessity, and because of the CLEO sign-off requirement, for some, they were. Around 2016, though, the Obama administration ATF cooked up Rule 41F, which very substantially changed the shape of the landscape here. The big change for individuals was the elimination of the CLEO sign-off requirement, replacing it with CLEO notification. Whereas before 41F, you'd need to get the approval of your local cops, now you just need to mail them a copy of a form they probably don't understand. Since the sign-off requirement disappeared, as did this benefit of a trust. Another big change was requiring every responsible person on a trust or other legal entity to submit fingerprint cards and photographs for NFA transactions. This made dealing with trusts, especially those with which amass NFA Firearms and have lots of members, quite cumbersome. It also meant the advantage of avoiding fingerprints, photographs, and Leo letters was eliminated for trusts. So, for the most part, the majority of pro-gamer advantages for NFA trusts were wiped out with 41F. It also kind of flipped the bit on difficulty, making filing as an individual comparatively easier and as an entity comparatively harder. The main advantages for NFA trusts are now possession by multiple individuals and estate planning. We'll dive into those next. So the big thing here that most of you are probably thinking about, possession. As we know, the NFA dastardly restricts possession to the entity the firearm is registered to. There are two main schools of concern here. Those who are worried about leaving their guns at home with their family members, and those who like to lend blasters to buddies. Two things I can relate to. First up, family ties. Many are worried that if they don't do an NFA trust, they and their entire family will be whisked away to federal prison if the registered owner puts the firearm down for even a moment. Well, there's a nugget of legitimacy to this concern, but only a nugget. Lots of Reddit lawyers will simply copy-pasta provisions of the NFA, sparking fear of the end times, without ever looking at the regulatory definitions or really thinking more than a mite. The Supreme Court has chided that there is no word more ambiguous in its meaning than possession. And that has got to be true. In some ways, this is helpful too. For one, possession has different meanings in the civil and criminal context. Plus, there's different forms of possession. I'm going to very briefly go over each of these. If you think these concepts need a video of their own, let me know down in the comments. First up, the common definition. This informs everything that comes. That is, the ownership, control, or occupancy of a thing, most frequently land or personal property. NFA Firearms, of course, being personal property. Actual possession, in the words of the Supreme Court, is what most of us think of as possession. That is, having physical custody or control of an object. This means, of course, having the thing in your hands. When you've got it in your hands, you're no doubt in a type of possession. But is it complete possession? For example, if you let your buddy shoot your shosha at the range, he's surely got it in his hands. He's surely got physical possession. But are they free to wander off and take it home? Of course you'd have something to say about that, right? And that's implied in the situation. That is not, in my opinion, a transfer of legally operative possession. It's still you, the owner, that really controls the item in that scenario. Then there's constructive possession, when the thing is not in your hands, but where you have knowledge of an object and the ability to control it. For example, something you put away in a safety deposit box or the pack of gum in your center console. It might not be with you, but it's yours, and you know it's yours, and you know how to get to it. In the criminal context, though, things get a little hairier. Historically, you had to have actual possession of a thing to be criminally liable for it. But in the Prohibition era, when a lot of the fabric of our legal system began to unravel, the courts began expanding criminal possession to include constructive possession as well. After all, there was no way they could enforce the whiskey ban when every time they found an unmanned truck loaded with hooch, they just have to shout "shucks" and not murder anyone. The booze ban led to quite a few Supreme Court cases involving criminal possession. One of the first Supreme Court cases to recognize constructive possession in the criminal context, 1920s People v. Vanderhyde, involved the cops finding intoxicating liquors belonging to one person in the possession of another. Subsequent cases, especially those involving the drug war, have continued to expand and torture the concept of criminal possession. That said, in criminal cases, intent is pretty much always an element, meaning the alleged possessor must know the item is illegal and that they are in unlawful possession of it. To make an NFA example, if one were to keep their legally owned suppressor at home, stowed away somewhere, and either saying nothing to their spouse or saying not to touch it when the owner wasn't around, I feel it would be hard for a claim of criminal possession to stick where the person simply occupied the same space. That said, many people choose to lock their NFA firearms in a safe their family members don't know the code to in order to stay on the safe side. There have been some cases that are quite alarming, many of which involving prohibited people. If you are living with firearms and a prohibited person, you should probably contact a gun lawyer to be sure you keep things straight. By the way, I've got some affiliate links to some recommended reading on the subject down below if you're just itching to be more familiar. Some have expressed concern about, well, what if my wife is home and a burglar breaks in and she happens to use my NFA firearm in self-defense? And this has led to some very interesting online discussions. If you want my opinion on this odd and thankfully unlikely scenario, then I'd just like to recommend you look into the legal doctrine of necessity. That said, if you want your spouse or BFF to be able to have free reign and control of your NFA devices, such as to be able to use them when you aren't around, then a trust is likely the way to go for you. How about the other thing I mentioned, though? Estate planning. Well, 41F also made it easier to pass your NFA firearms down to your descendants, so that advantage of a gun trust has also kind of gone away or just been whittled down a bit. However, if you've got no will, or you're just concerned your family members might not want your NFA firearms, having a trust set up for where the firearms go with some alternative options in case your favorite friend predeceases you is a great way to keep your guns from the crusher. I do have it on good authority that a great many transferable machine guns have wound up in the hands of the ATF after family members didn't want them and ATF fed them to Captain Crunch. Very sad. Many such cases. So yeah, in short, most of the reasons for getting an NFA trust have indeed disappeared, but some certainly remain. If you need to let another person have full-on possession of your NFA firearms and borrow them, or if you're concerned your descendants might let the ATF eat your MGs, I'd say go for it. That's it for today. Let me just say I really appreciate you guys watching and subscribing. It makes a huge difference. If you want to support me more than that, I started up a Patreon and a Subscribestar. I've added benefits like a patron-only podcast, a Discord, and there's surely more to come. This kind of support will help enable me to make more content more regularly, something I'd really love to be able to do. There's also a link to the Fuddbusters sticker and the Magic ATF ball in the description below. Thank you all so much for watching to the end and for your support. I'll see you next time. Or if you become a patron or Subscribestar, I'll see you on the Discord. Remember guys, the anti-side has been working long and hard passing laws and trying to make more. Anything more than minimum compliance is self-regulation. Y'all take care.